Hello, everyone, and welcome to the Kelleher and Holland webinar series, Your Legal Compass, where we help you navigate estate planning, trust administration, and elder law with clarity. When it comes to estate and trust planning, many families feel like they're sailing in uncharted territory. Tax rules have shifted, and trusts that were drafted for calmer seas may not perform the way they were intended now. So that's why today's program, Is Your Trust Still Seaworthy?, is so timely. We'll focus on how modern trust planning can reduce unnecessary estate and income tax drag, protect beneficiaries, and help families with significant retirement assets avoid unintended tax exposure, often by updating existing plans rather than starting over. We encourage you to submit questions using the Q&A button in the Zoom control panel. And time permitting, we'll address them live at the end of the presentation. If not, we will follow up with you directly after the webinar. Today's captains are Monica Gurgiolo and Michael Fioretti. Monica is an attorney, CPA, and co-chair of our estate planning and estate and trust administration groups. And Michael is an estate planning and corporate attorney licensed in 3 states. Both of them bring deep experience in estate, tax, and asset protection planning to today's discussion. And with that, I will turn it over to Michael to get us underway.
Sure. Thank you, Amy. The the first thing that we want to talk about is revocable living trusts and our perspective that why everyone still needs at least a revocable living trust. Now, what's a revocable living trust? What does it do? How is it different than just a will? Well, just a will is a document that provides for the disposition of your assets at death, but it subjects your assets to probate. And probate is the court process that will manage and guide your executor through the post-death process. But it is a court process. It's a public proceeding, and it's not private. It's a public proceeding that anyone can show up to, anyone can find out information about. And so we use trusts to avoid that court process because they're private and they do a lot of things that simple wills don't do. But revocable living trusts are not just about avoiding probate. And it's not just for people who have substantial wealth or taxable estates. We hear that very often, that trusts are just for people who are extremely wealthy or have really complex estates. For whatever reason, the phrase that, the trust fund baby or the trust fund kid, and that's somehow entered into our lexicon and has influenced people into thinking that trusts are just for the super wealthy. And the reality is that's not true. Revocable living trusts give our clients the privacy that they're almost always interested in. They can maintain privacy among their family or friends or whoever their beneficiaries are. And they can maintain control. They get to decide who's in charge. They get to be in charge while they're alive, and then they get to designate their successor trustees after they're gone. And then it provides protection and efficiency after death. And we'll talk about that a little bit more as this webinar goes on. But also more specifically for today's discussion is that we can provide some income tax efficiencies as well, which is really nice. And that's what a lot of trusts don't do. They don't provide for income tax planning at all. And so that's what some of the things that we're going to talk about today do. Trusts at least with respect to privacy, control, asset protection, we can do a lot that ordinary trusts do. We do a lot of it just by doing revocable living trusts. But if you have retirement accounts, which can be a substantial part of your estate, and historically, uh, the bulk of people's estates was their home. That was the biggest asset that they had. But now that people have moved away from, and companies have moved away from things like pensions and things like that towards 401ks, IRAs, we're seeing a lot of people have substantial parts of their estate in retirement accounts. And these retirement accounts, if the beneficiary designations are kept in the way that most of the time they are, just to spouse or just to kids, those will act independently of a trust. And while that can be simple and easy to administer, those types of beneficiary designations can lead to some problems. Because say, for example, you've got your kids as your beneficiaries on your retirement accounts or on other assets. What if those beneficiaries are minors at the time of your death, or they're incapacitated, or they've got creditors? There's some credit card debt or medical debt out there, or they're married and then they've got an estranged spouse, or potential divorce looming. And alternatively, what if your beneficiary, your children or whoever else, have a sizable estate of their own? Maybe they've done really well for themselves, and inheriting an asset from you would add to their taxable estate. That would be a really big problem. And this can be a concern, especially if they don't live in the same state as you. I mean, we're going to be talking about the taxable estate situation here in Illinois, but if they live in a state which has a state that has a lower estate tax exemption than Illinois does, leaving assets to them outright can be a big problem. It could cause them to incur estate taxes where otherwise they wouldn't have estate taxes. And so generally, our approach is to avoid leaving things outright to beneficiaries, and so we instead do the alternative, which is leaving assets in trusts to your beneficiaries. These types of trusts for beneficiaries, for children, surviving spouses, are private, and so we don't have to go to court to administer them. We don't have to let anyone, outside the family know about who the beneficiaries are, what the terms are, and we can save a lot of fees. We don't have to go to court. We don't have to show up on a judge's schedule or anything like that. We can administer things privately, which is really nice. You get to designate who the trustee is, so you get to pick who's in control. And then you get to pick the rules of distribution. How does the beneficiary get assets from the trust? For what reason? What rules is the trustee going to be subject to? Do they have how much decision making do they have? Decision making authority do they have to make distributions to the beneficiary? That's all things that we talk about with our clients very frequently. And we've got a lot of experience in the area, so we can give you very good advice on what works, what doesn't work, and why. I'll Another thing that, as we touched on before, was taxable estates for beneficiaries. Trusts, and one of the major reasons that we use trusts for kids is that any assets that end up in those trusts are outside of that beneficiary's taxable estate. Whereas if you just leave an asset to them outright and free of trust, that asset becomes part of their taxable estate. So when they pass away, long time from now, um, their estate will be taxed on that asset or those assets for them. Whereas if we leave it in a trust like we do, those assets would be outside of their taxable estate, at least in most cases. And we're going to get into some exceptions to that in just a moment here, especially when it comes to retirement accounts. Retirement accounts, as we were talking about before, can move independently of trusts. You've got a trust that you've set up, you've drafted all the rules, you've decided who you want to be in control and all of the disposition terms. But if you've got a retirement account and you've got beneficiary designations on that retirement account, that will go pursuant to that beneficiary designation. And so if those two things aren't coordinated, well, you've got two different lanes, so to speak, where we've got assets flowing through. Um, so really, a lot of people have this idea that you can't coordinate a retirement account with a trust. And usually what they're thinking about in that sense is that it's generally a bad idea to have a retirement account, an IRA, for example, owned by a trust. And that's because if you were to do that, if you were to move that retirement account to a trust, that'd be a taxable distribution. You'd pay a whole bunch of income tax. It'd be really bad. But instead, what we do is we want to have the beneficiary designations of those retirement accounts. Instead of pointing directly to the surviving spouse or directly to your kids, it'll instead go to the trusts that get set up for those kids. It'll instead go to something like a family trust for a surviving spouse. And why would we want that? And that's because it would get all those benefits that we were talking about before with respect to asset protection and maintaining privacy and having those distributions from the retirement accounts being outside of the taxable estate of the beneficiary. However, it is not quite as simple as just naming your own trust as the beneficiary of a retirement account. It's a lot more complicated than that. And that's where Monica is going to come in. She's going to talk little bit about coordinating retirement accounts with trusts and how we go about doing that, some of the rules.
Thanks, Michael. Yeah, just one other side note. In this presentation, we were not planning to go into the details of the mechanics and what a revocable living trust looks like and the funding process. We do have another webinar on our website if you wanted to learn more about that. We just kind of skipped all of that so that we could get into these other discussion points. So one of the big aspects with retirement accounts is the income tax. They are deferred income tax accounts. So as the distributions are made, the income tax has to be paid. So we're going to get into that, but I just wanted to take a step back and do a quick overview of income taxation as it relates to trusts. So when we're talking about revocable living trusts, which is our most common type of trust that we set up for people, those are set up as what's called a grantor trust, meaning the person who sets up the trust is sometimes termed the settlor, the grantor, or the trust maker. That's all the same person. So during their life, the income that is generated on assets that are in the trust are reported to the trust, but under that grantor or settlor's social security number. So there's no separate taxpayer ID number for the trust. There's no separate income tax return required for the trust while the settlor is alive. The change occurs after that settlor passes away. Their trust now does become a separate taxpayer. Their social security number can no longer be used. It becomes a non-grantor trust immediately upon their death. The difference in income tax treatment is very significant because now that income that was previously taxed to that grantor under their individual income tax rates on their return now is subject to income tax at the trust level. The trust income tax rates are highly compressed, meaning that we reach the highest rate of 37% at only about $16,000 of income. That's this year's number. Whereas for individuals, you don't hit 37% until a much higher income. So even more so today, like Michael said, so many of our clients have such a large portion of their estate, their wealth is tied up in retirement accounts. And you've got all of this deferred income tax waiting to be recognized. So we don't want to ignore them. They're a large part of the estate. We can't ignore that, and we can't ignore the income tax on it. So if we want to incorporate those large accounts or significant accounts, they don't necessarily have to be large, but large in respect to the client's or the person's overall situation. We want to take those into account and have the same benefits of the trust that Michael was talking about apply to those accounts. So we have to structure those trusts very carefully so that they meet the requirements of a trust that the term is a see-through trust that can look through the trust to the individual beneficiaries and get the same income tax treatment and distribution requirements that would apply to the individual had the account been left directly to the individual. And that's as a result of the Secure Act and Secure Act 2.0 that came out originally in 2020 and has been changed. And there's been all kinds of proposed regs and final regulations. So there's a lot going on there in order for these trusts to qualify to be a beneficiary of these accounts. A lot of it is income tax driven. And we want to be sure that the trust is going to qualify so that whatever the longest payout term that the beneficiary would be allowed to have, had it been paid to them, will apply. So that's what we're looking at when we're designing these trusts and wanting to, be sure that it's going to work and not be an income tax nightmare and cause all kinds of unexpected results. So that's that. So if we look at our traditional trust, a traditional non-grantor trust that is what you end up with when the creator or the settlor of a revocable living trust dies, doesn't work, unless you have these provisions. So the norm for those is that the trust receives the income. There's 1099s reporting interest, dividends, whatever the case may be, maybe rental income on a property that's held in the trust. If the income remains in the trust has to pay the income tax. If the income is distributed out to the beneficiaries, the income tax is then paid by the beneficiary. That's a very simplified way of looking at it, but that's just just the way to understand that. So the other part of that is that now the trust, like I said, is its own separate taxpayer. You have to file an income tax return each year for that. You also have issues with certain attributes that you need for example, an S corporation to be owned by a trust. During the grantor's life, it's not a problem if it qualifies as a grantor trust. That's an eligible S corporation shareholder. A non-grantor trust is typically not an eligible shareholder. Also, capital gain and other tax attributes that would apply to an individual, for example, a surviving spouse trying to sell a primary residence. If that home is not owned by that spouse and instead is owned in a family trust for his or her benefit, you don't get the benefit of those other attributes that you would have as an individual. So we wanted to come up with a solution for that so that we could have the best of both worlds, the benefits of the trust and also a more favorable income tax result. So Michael is going to talk about what we do to do that.
So our solution is what we call BIAT, B-I-A-T, Beneficiary Income Accumulation Trust, and it's designed to address the dilemma that people have had for a long time about using trusts, leaving assets outright to beneficiaries, and sometimes doing a little bit of both. Because we've got this issue where assets end up in a trust, but because of the high income tax rates of the trusts, the trustees, very often you read older trusts, and it wasn't wrong at the time, but what these trusts often say is, I direct my trustee to distribute the net income of the trust annually to the beneficiary. Now, when the income of that trust wasn't very much, that's not that big of a deal. The income that gets distributed out to the beneficiary, they pick up that income on their tax return, and it's generally okay. But now, because of the Secure Act, and we've got this 10-year rule, we've got really big distributions hitting these trusts. And if under an old-fashioned trust, what does the trustee have to do? They've got to distribute that income out to the beneficiary. Good income tax result. But remember all the benefits of those trusts that we were talking about, the asset protection and the privacy and being outside of the taxable estate of the beneficiary. Well, all that income, those giant distributions that come from those retirement accounts, that all gets distributed out to the beneficiary. It loses all of those really cool features of these trusts. And so BIAT solves that problem. It allows the income to stay within the trust, receive all of that protection, the estate tax, being outside of the taxable estate of the beneficiary, the asset protection, the privacy, it allows it to keep all that without having to distribute the income annually to the beneficiary. So we can keep that income, which remember, those are the distributions from those retirement accounts and maybe even capital gains or dividends, things like that. That can all stay within the trust, and we get the beneficiary's tax treatment at the same time. And remember, most of the time, unless that beneficiary is an extraordinarily high earner, that tax treatment is going to be a lot lower than what the trust would be, because the trust would have had a much higher tax rate, probably 37%, versus if the beneficiary was making, say, $100,000, $150,000 a year, they'd be paying 22, 24% tax rate. That's a really good tax savings when we keep that income in that trust. So it's a really good tax result, and it's also a really good asset protection result as well. But you might be thinking, well, BIAT sounds great, but we're talking about a lot of money, a lot of income here. Is it just for people with, tens of millions of dollars? And the answer is no. And the reason the answer is no, and why it can benefit most families, is because there's not just the income tax benefit to it, and the asset. It's not just the income tax benefit; it's also the asset protection benefit. But we can also cut out a little bit of red tape too, because like Monica was saying, we can have these trusts that get created for your beneficiaries treated as one and the same as the beneficiary. So what that means is that we don't have to file separate tax returns anymore for the beneficiary and the trust. We can just file one tax return. The beneficiary can just use their own income tax return and pick up that income on their own return that they receive in the trust. So no more separate tax filing. You don't got to file to prepare separate tax returns. That saves a bit on administration expenses and hassle and things like that.
Just one
And
note
then,
on that.
yeah.
Sometimes it depends on the CPA you're working with or your
Mhm.
client is working with, or the tax preparer. If a return is needed for the trust for whatever reason, it's a much simpler return, meaning you can just put a statement on there that all income that's reported to this trust is being reported on, this 1040, the Social Security number. So it simplifies it, even if you do have to file a return. But ideally, you shouldn't even have to file a trust income tax return each year.
Yeah. So, and most people, wealthy, not very wealthy, most people are interested in efficiency. And that's really what we're talking about here. Biat is offering our clients efficiency when, something really bad happens, someone's passed away. That's not good. But if we can offer a little bit of efficiency, I think that's a pretty good result for our clients. And just kind of the last thing here, at least with respect to some of the things that these types of Biat trusts can offer that income that stays within the trust, when it gets if it were to get distributed out to the beneficiary, remember we were talking about how when assets go outright to a beneficiary, they become part of that beneficiary's taxable estate. Biat allows that money to stay within the trust and outside of the taxable estate as well. So again, think retirement accounts getting distributed to these trusts. All that money gets to stay within these trusts and outside of the taxable estate of the beneficiary. So that's an income tax win, but it's also an estate tax win as well. Um, so the problems of old and traditional trusts is that some of the things that we've been talking about already, people end up, they were under this dilemma always that do I keep the money in the trust and maintain the asset protection and keeping it outside of the taxable estate, or do I have the money, the income distributed out so that I get the better income tax result for income tax purposes? That was always the trade-off that you had. Biat solves that problem, and we really get the best of both worlds, especially when it comes to larger distributions from these retirement accounts, which, as more and more people have greater and greater IRAs, 401ks, things like that, and are subject to this 10-year rule, the beneficiaries are subject to this 10-year rule, the benefits just become magnified even greater.
Uh,
Um,
so
yeah,
trusts that were done previously that don't include this don't have those benefits. So
that's right.
sometimes those are revocable trusts that you have, maybe you've inherited from somebody else's trust. So that's what we're looking at when we're reviewing trusts that people provide to us that they've already got.
And that's very often the case where someone has set up a revocable trust of their own, doing normal estate planning, did it a couple years ago or even a couple of decades ago. But then at the same time, they received a trust from a deceased grandparent or parent. And so they've got multiple things going on. And they wonder, okay, well, can I put Biat in this trust? This inherited trust, can I put Biat in that trust? Because, I've got some tax problems with this trust too. And the answer is for the revocable trust that they set up themselves, that's something that we can very easily do. That's an easy upgrade that we can provide either through a restatement or an amendment. But that's something that we do all the time for our clients. And again, it's not just for people with, tens of millions. We got clients of all wealth levels who are very interested in Biat, and it's working very, very well for them. And when we do that, we preserve their original intent in setting up these trusts. We don't have to like change who their beneficiaries are or, have the trustee be some wacky third party. No, it can be still family members, all the same people that you've wanted historically. It's just we're improving the income tax efficiency, the asset protection, the estate tax planning. And then with respect to the trust that someone might get from a parent or a grandparent, something like that, it is achievable, but it really does depend on the circumstances, depends on the situation. We'd have to take a good look at a trust like that. So classic lawyer answer, it depends, but there are opportunities out there to upgrade trusts like that. We would just have to take a look at those sorts of trusts and let you know what's possible. But if it can be done, we would certainly want to do it. This is where I'm going to turn it over to Monica to talk a little bit about the Illinois state tax exemption.
Yeah, thanks, Michael. So we've been focusing a lot on income tax, which is so important because that affects everybody. There are a number of people who are affected by the estate tax and really specifically the Illinois estate tax, if not the federal. So just quick overview there. The federal estate tax exemption as of January 1st is now at $15 million. So historical high number there. And that is indexed for inflation each year starting next year. The other advantage there is that it is portable. So what that means is if we have a married couple, for example, who did not do any estate planning and their plan is very typical, leaving everything to the surviving spouse via will, trust, beneficiary designation, joint ownership, whatever it may be, that's going to be okay at the first spouse's death because there is an unlimited marital deduction. However, they didn't use any of that $15 million exemption that was available to the first spouse because that is a per person exemption. The surviving spouse can, by filing a federal estate tax return, elect to carry over that unused exemption and just add it on to what they will also have at their death. Problem is Illinois. There's a trap because people are focused on that oftentimes and don't realize that Illinois is sort of waiting in the wings, and we just have a $4 million exemption per person in Illinois. And further, it does not allow for portability. So if the first spouse dies in that example I just gave and everything goes to the survivor, you've lost it. You cannot carry it over. It's gone. So you have to use it. You have to plan for it while both spouses are alive so that we can use at least some of it at the first spouse's death, even if not all of it. We don't want to give it all away. So the way it's that exemption is taken, if you will, is by usually parking some portion of that first spouse's assets into a credit shelter or a family trust. That trust is designed so that it will use up some of that exemption. The exemption will apply to it. It's not using the marital deduction. So now whatever ends up in that trust does not get taxed in the surviving spouse's estate later on. And now the surviving one upon their death has their exemption. So that's how we're trying to take advantage of both exemptions that each spouse has. Keeping in mind that the retirement accounts are includable in that calculation of an estate when we're looking at whether an estate is over or under the applicable exemptions. And it's often ignored as part of the planning because those accounts are difficult to work with for all the reasons we've been talking about. So we don't want to ignore them because it's often a lot of money, and often the largest portion of somebody's value, their wealth, is in those types of accounts. So that was not an option for us to just ignore that when we're doing planning for our married couples. We want to use that exemption. So what we ended up doing is designing and creating a specific retirement benefit trust that is designed for this purpose so that it can be used so that we can capture some or all of that Illinois estate tax exemption at the first spouse's death and use retirement accounts to do so, which again, oftentimes those are ignored when you're looking at what can we use to fund that credit shelter trust. Retirement accounts are too difficult. We take them off the table and you end up with this estate tax that didn't have to be paid if we planned and those accounts were used as part of that funding process. So what we
And just
wanted,
really quick, a lot
yeah.
of times that just gets caught up in the shuffle of post-death administration. We've
Mhm.
got a retirement account from a deceased spouse, and one of the first things that our clients get asked to do is just roll over that account into their name. And that's the situation. If we're involved, we're going to say, hold on, let's bump the brakes there. We want to really think about whether that makes any sense. And that's where this RBT, if it's in place, it can really help save a lot in that sort of a situation.
Yeah, and that's so important what you just said is if we're working with a couple, I stress that point so many times. I think they're sick of hearing it, is we're going to set up this retirement benefit trust. We're going to set up your beneficiary designations in a very specific way so that it works with the trust and it's so important that the surviving one doesn't just immediately start signing rollover documents. And I understand that advisors are often trying to be very helpful and they're trying to make it as easy as possible for this recently widowed person and say, here, just sign here, we'll take care of it and we'll roll everything over. Well, with our planning, that's a disaster because we're going to help you set it up so that you don't have to do that, and instead those accounts or some of them can be funneled into a family trust that is designed again to use up some of that exemption, the Illinois estate tax exemption, but also there's some options there and some flexibility for the surviving spouse to kind of set it up so that that trust is going to be the most beneficial for them and their family under whatever those circumstances are at that time. So what we're trying to do with this trust and the beneficiary designations is lay the groundwork so that the surviving spouse has these options and can make the decisions at that time. Because as we know, the tax laws change and they're going to continue to change. The asset values of a family change. The circumstances of their children and their family are going to be changing. So at that moment, at that point in time, can be when that decision is made. So it's, we set it all up and it's all there, waiting to be implemented at that point. And
And
of
really
course,
what that's all about is that rollover, signing that document. What's happening there is that it gets rolled over into the surviving spouse's taxable estate, and it misses the deceased spouse's
Mhm.
estate tax exemption.
Right.
That's what we're solving for, is that problem. Because again, the rollover is easy. It's quick. It's just sign a couple of pieces of paper, and we'll get it rolled over in your name. It'll be great.
Mhm.
But what
Yeah.
is that? It takes that account and it puts it into the surviving spouse's taxable estate, and then we miss that exemption that was available to us.
Mhm.
This trust allows us to solve for that problem, and it just gives us more options to capture that exemption when it's there.
Yeah. And because the retirement accounts, like we were saying, have all of this income tax drag on them, we of course are including our BIAT provisions in there, which will apply to the trusts that are set up for the surviving spouse and also for the children, grandchildren, whoever the beneficiaries are after both spouses have passed. One important note, which I don't know if we mentioned or not, but with retirement accounts, you may or may not know, during your life, if I have an IRA or 401k, there's some asset protection for me. My creditors can't reach those. When I die and I leave that account to somebody else, one of my children or both of my children, now they don't have that same protection, which is why it's so important and why we stress the importance of trying to get those assets into a trust for all the reasons we were talking about and have those benefits also have that trust protection bubble around them. So it's a matter of putting all of these pieces together so that we can get all of these benefits that we want for our clients. It's that important.
Mhm.
So that's what we're trying to do with this trust and the beneficiary designations and like I said, kind of laying the groundwork and incorporating those accounts as well as this trust into the overall plan with the revocable living trust, which will have all of the other accounts and real estate and whatever else might be part of the estate. So that's what we're trying to do here. Um, Anything else you want to add on that, Michael? Otherwise, I was going to switch gears to quick note on life insurance.
No, I just like conceptually, I want people to think about these retirement accounts are kind of like buckets filled with water, and these buckets have asset protection on it. While the owner of that bucket, the person who set it up, is alive, and that asset protection is really great. But if we take that water and we start to drain it out
Mhm.
into not into another bucket, which is protected, but just straight out into somebody else, it loses all of that protection, and that's kind of how trusts work too, is that
Mhm.
they're designed like buckets to hold assets, and we've got rules around those, and those rules give us the asset protection. And we just want to make sure that we take the water from one bucket and put it into another that's got a really great set of rules around it that we get to decide. Our clients get to decide what those rules are.
Yeah, well said. So one other very important asset that is sometimes forgotten because clients don't necessarily, people don't necessarily realize that life insurance is actually a big part of when we're looking at what's in your taxable estate. So we ask about it. We want to know, do you have term policies, whole life, joint, second to die policies? What do they look like? And what's the purpose of them? because we need to add that into our equation when we're determining if you have a taxable estate or not. So if it's a $2 million death benefit and I own the policy, that's $2 million more in my taxable estate when I die, even though I have no benefit from it during my life, especially if it's a term policy. So we do need to keep that in mind. And often a simple-ish solution to that is just creating an irrevocable life insurance trust. And there's a lot that goes along with that that we're not going to get into here. But that's a way that we can remove life insurance from your taxable estate and still have your family be able to have the benefits of that life insurance when it's paid. And again, we're going to coordinate that with the other trusts and the overall plan. That's always what we're looking at is how does everything fit together so that we don't miss anything. So we wanted to just go into a couple little examples so that you could see how this would work in different situations. And Michael's going to talk us through the first one.
Yeah, so this first case study or just example case, we've got a married couple, $3 million estate. And remember, in the state of Illinois, we have a $4 million exemption per spouse, not portable, but it is per spouse. So if this client, this couple comes to me and we've got a $3 million estate, not looking at a taxable estate right now, but in the back of my head, I'm thinking, depending on age, there could very well could be a taxable estate at some point in the future. And we're going to want to look at what's your asset profile. Is it all tied up in retirement accounts? Is it, 1 million is in primary residence? Is it all in an investment, or is it a blend of things? Most commonly, it's a blend of things, but a lot of times we see very, very heavy on the retirement accounts and then more modest on the other accounts. But a lot of times it is a mix, and more often it is spread out between the couple. It's not just on one side. It's not just one spouse has everything and the other spouse has got nothing. It's very often spread out between the two. And so say this couple comes to us and they want to either update their estate plan or set up a new estate plan. We'd be looking very closely at their assets, trying to lay everything out, who owns what, what's the value of everything. And then we would want to do just like almost like I said before, almost all of our clients are going to be better served by a revocable living trust. We would do trusts with our BIAT provisions, which again are not just for the super wealthy federally taxable estates, but more like a non-taxable estate like this, not taxable right now in the state of Illinois, but we get better income tax results and we get better asset protection for the beneficiaries. And then again, depending on the makeup of the actual estate, an RBT might make sense, especially if it's one spouse has got, say, a $2 million IRA, and there may be very good reason to want to disclaim that into a family trust, like Monica was talking about. But we get all the benefits that we were talking about with BIAT, with the income tax benefits and the asset protection. This type of a case does, like I kind of mentioned, we want to pay attention to the age of the client. We want to know, okay, if this is a younger couple with 3 million, there's a very good chance that they're going to have a taxable estate at some point in the future. And to not plan for estate taxes in that sort of a situation would be a really big mistake. So our trust will certainly have all of the estate tax provisions that you would expect in a very robust estate plan. And even if it's an older couple, they're retired and they've got a $3 million estate, assets, especially if they're well managed and invested these days, can grow significantly over 5, 10 years. And a lot of people are surprised they've got a taxable estate as
Mhm.
time goes on. And so it makes a lot of sense to have both trusts, BIAT provisions, and then depending on the circumstance, a retirement benefit trust could make a lot of sense as well. So Monica is going to take us to the next step up. We're gonna double the size of the estate
Yeah.
and talk about a little bit more that we can offer in this sort of a situation.
Yeah, so in this example, we have a couple who currently clearly has an Illinois taxable estate if they were to do nothing. So do nothing, first spouse dies, $6 million all ends up in the surviving spouse's estate, and they only have a $4 million exemption. Not a good result. So what we want to do is do some planning with them while they're both here, and we can do so. And in this case, depending on the makeup and how much those IRAs, 401ks are, which or both of the spouses have those accounts, and the makeup of the other assets, this could be a prime case for the retirement benefit trust that I was talking about, where we set it up. We have the beneficiary designation set up, sometimes with the spouse as the primary beneficiary, but the ability to disclaim. Sometimes we'll go right to a trust within the retirement benefit trust. It really depends on the circumstances, and that's what we talk about with you when we're designing this. But regardless, that's what we would probably be doing here if the numbers make sense to do so. We'll also be setting up a revocable living trust or restating existing trusts that you might have so that we can incorporate the BAT provisions into there, which are going to be very beneficial to the surviving one of you and also your children, your grandchildren, whoever those beneficiaries are, so that they've got that ability to keep the assets protected in the trust and still pay the lower income tax. So that's probably going to be make sense in most cases. Depending on the life insurance, maybe we set up an ILIT, an irrevocable life insurance trust, to either transfer that insurance into. Sometimes we're looking at purchasing new insurance, maybe to fund if we know we've got an estate tax and we have assets that don't really want to have to sell to pay that estate tax. Oftentimes setting up an irrevocable life insurance trust and that trust purchasing a new policy really for the purpose of funding that estate tax liability, paying it, can often be very beneficial to the family. So we'll look at that. And overall, what we're trying to do here and what we would be able to accomplish is some significant estate and income tax savings and continued protection for your family after you're gone.
And a couple of things about a case like this. Sorry, just really
Hmm.
quick on case two. There, cases like this are always really important to go through the assets and make sure that we know about everything, because very often we have clients that come to us and say, I've got a $6 million estate. Here's everything. I've got this big brokerage account. I've got a couple of homes, and here it is. Or retirement account's got a ton of money in it. And then they never mention life insurance. And then we ask, okay, well, do you have any life insurance? And I'm like, oh yeah, by the way, each of us have got $1 million life insurance policy. And so it turns from a $6 million estate to an $8 million estate. And remember, life insurance is includable in your estate for estate tax purposes. And so it's very, very important to have these conversations about what your asset makeup is, who owns it, where it's all going to go. That's all things that we will do as part of an estate plan for our clients, is to have that conversation and to be very informed about where everything is. And then also just really quick on the one or two homes part, we always want to pay attention to where real estate is located, because if you've got, your primary residence here and then a cabin in Wisconsin or a condo in Florida, we're going to want to make sure that that second residence is in your trust, coordinated with your trust in some way, because if you just have that owned in one spouse's name, you'd be looking at what's called an ancillary probate in that other state. Most people find that to be pretty inconvenient. So we'll make sure that that gets coordinated as well.
Yeah, I mean, that's really what we do. I mean, that's kind of, we were
Mhm.
going to end up with that, but we look at everything. We're going to
Yep.
prepare a spreadsheet where we can see everything. We're not doing a trust or a will in a vacuum without really
Mhm.
digging into all of the accounts, how they're titled, and what does it mean to put one into one trust or another trust, different state rules or laws and things
Absolutely.
like that.
Absolutely. So, um, third case, single individual and $3 to $5 million estate. So they've done pretty well for themselves. And when we've got a single individual, a client who's single or widowed, we don't have the ability to use that estate tax exemption upon their death. It's just the money is going to go to their beneficiaries. And so, in a situation like this, say they've got three kids, $3 million. Each kid gets approximately $1 million. Where we were talking about the difference between trusts and outright distributions, this is going to be pretty important in a situation like this. I'm going to want to use trusts, especially because if you think about that say $1 million, if that goes outright to a child of this particular client, and that child lives in a state with a very low estate tax exemption, say Connecticut or New Hampshire or one of those other, a lot of the East Coast states have very low exemptions. That $1 million will become part of their taxable estate, and there's a very good chance that that child will have a taxable estate because of the money that they inherited from mom or dad. And so we can avoid that by using, again, trusts, and in particular trusts with BIOT, because BIOT will allow us to keep any of the income that ends up in that trust. It allows it to stay there outside of the taxable estate, getting all the asset protection benefits that we've talked about as well. And again, we're going to want to look at the retirement benefits to make sure that that's all coordinated with the trust. Make sure that it's not just outright to the beneficiaries, rather that it's coordinated with the trust that we set up for um, for the kids or the beneficiaries. So we're going to pay attention to all of that. Also, life insurance and all the other assets as well.
Yeah, I mean, we could talk, there's so much more
Hmm.
here and when, that we do get into with our clients. So that's really what you get when you come to Keller and Holland is that experience with us. You're dealing with experienced attorneys who do both planning and administration work. So we see these things on the back end and know kind of what works and what doesn't work. So our first meeting is a lot of information gathering, really just talking to you to find out as much as we can about your family, your assets, your concerns, all of that. And then we start to work toward a design that makes sense for you. And then obviously we implement it. We draft the trusts. We help you, we tell you and go through how you should be titling different assets and what your beneficiary designations need to look like so that everything's going to work the way it should, considering the planning. So, and we do look at not just you, but like Michael's saying, we consider who your beneficiaries are and what their circumstances, their tax situation. Maybe they're in a high risk profession, so that asset protection is very important. Maybe they're in a rocky marriage. Whatever the circumstances are, we do try to take that into account too, because it really helps us give you the best plan.
So what's next? If you've got trusts out there that you did a couple years ago, many years ago, we'd be happy to review those, let you know what we would do different, solutions that we would have. And we'd take a look at your asset profile too. So something like a summary net worth statement or just a list of your assets that you've maintained. We'll take a look at that, see who owns what everything's worth, determine whether you've got any estate tax exposure, depending on how the assets are owned. And then what the opportunities are in terms of estate planning, whether um, BIOT or an RBT makes sense. And like we said, BIOT makes sense for just about everybody. It's something that is a really great
Yeah.
solution, works very, very
There's
well.
Yeah. There's some cases like
Yeah,
if we have a special needs
right.
beneficiary, there's
Yep.
certain places that be out won't work. And
Hmm.
that's why it's important that we understand, as much as we
Yep.
can about you so that we don't put something in that's actually going to be harmful. So,
Yep, there are reasons that make BIOT work, and those
hmm
same reasons could make other things not work. And so we've got to be
exactly.
very careful when we talk to a client. Okay, tell us about
hmm
your beneficiaries. Where's this money going to go?
hmm
What are they like? You got kids that are very well-to-do adults who know what they're doing, or do you have people who maybe have issues of their own or have some disabilities and there's things going on in their lives? We have those
hmm
conversations all the time. That's part of our profession and our practice is to do
hmm
that. And because we want ultimately to have the best plan for you and give you the best result. It's not for us, it's for you. And so it's our goal is to make sure that your estate plan is the best that it can be. So
All right. Thank you, Monica. Thank you, Michael. It was a very informative presentation. And thank you, attendees, for joining us today. We hope that you also found it informational as well. Feel free to contact either of our speakers today directly for further guidance. I have their contact information up on the screen for you. I did see a few questions come in. We are a little bit over time, so thanks for hanging in there with us. We will follow up with you directly. And honestly, I think what we'll do, because these questions were really informative, is we'll share with the group here all the questions that were asked and the answers to those questions to the entire group. So look forward to your inbox for that information, and also check out our social media pages for details on our next webinar in this series. Or if there is something that you'd like to know more about, drop us a line at attorneys@kelleherholland.com. See you next time.
Thank you so much for joining us.
thank you, everybody.